Hello, my name is Jim Blackburn, and this is the first of a 3-hour program in ethics and professionalism. It's entitled Good to Great: Lawyers, Paralegals, and Clients. This particular program is a study of the relationship between lawyers, clients, and how to make that a better relationship than perhaps it now is for you. It also is helpful for paralegals as well, and maybe you can see a little bit of the relationship between attorneys and paralegals and clients here. This program has to be interactive in order for anybody to get approved bar credit. That means that I am going to ask you 2 or 3 questions sometime during this hour program. And it is my hope that you will, once you have seen the entire 3-hour program, write to me an email at jim@blackburnseminars.com, jim@blackburnseminars.com, and let me know the questions and answers. The reason for this is not to quiz you particularly, it is to simply make certain that you have seen and listened to the entire video presentation. If you should have any questions, you can stop watching it and give me a telephone call at area code 919-326-9070, 326-9070, or call me on my cell phone, which is 919-889-7316, 889-7316. The idea for this particular concept of a program really has its genesis several years ago when I was traveling to New Mexico to make a presentation for lawyers for the New Mexico bar. One evening I placed a phone call back to North Carolina to get my voicemail messages. And in doing so, I'd gotten a voicemail from Wade Smith, a lawyer in Raleigh, who was my attorney many years ago. And he was telling me about the representation that he was doing for another client in North Carolina who was in some jeopardy and wanted to know if I would be willing to speak with this person. I said that I would. And we got into a discussion of what result he might be able to get for this lawyer who had violated some particular rules or principles, but his life career was not over. So what would happen? And I think it was Wade who said, well, Jim, he says, I've always believed that the best lawyers, the best attorneys, are those persons who can help a client improve his or her legal situation from where it was when they first became your client to where it is at the end of the representation, whether it's in court or settlement or however it's resolved. You've improved it from one point to the other point. And I agreed. I listened to him and I had to agree. I've thought about that concept a lot over the years because during my time as an attorney, like all lawyers, I was always ambitious to do better. And I thought in terms of doing better as to what kind of clients I had, or what kind of cases I had, or oftentimes how much money I made, or whether or not I was in a law firm. And if I was in a law firm, was I a partner in the law firm? And if I was a partner in the law firm, what ranking did I get in terms of its compensation? And was I eligible for a bonus at the end of the year? And what did my peers think of me? I think I interpreted my career, honestly, more along the lines of those external guidelines than I did on the concept of my relationship with clients. There are really two ways to determine what kind of lawyer you are. One is what I've just suggested. How much money are you making? Are you a rainmaker? Do you bill a lot of hours? Do you bring in lots of clients? Do you have lots of associates, working for you? If you're a paralegal, are you a great paralegal? Are you take no prisoners? Are you really tough? Can you work for more than one attorney at the time? Are you one of the best that will go to court with them? What's your relationship with clients? And that brings into the second part of the equation is, I don't know that I ever considered judging what kind of lawyer I was by my relationship with my clients. I don't know that I ever judged a paralegal by his or her relationship with clients. I remember once when I was waiting tables at 42nd Street back in the 1990s, and we got a new manager, and they were having evaluations of all the wait staff. And I was never regarded as one of the top waiters. Some of the managers there would still not think that, because I did not know the ins and outs of waiting tables and the menus and the kinds of beers and wines that we sold and where all the seafood came from, as well as someone else. I couldn't explain exactly how the chef made a certain kind of dish. But what they always confused them was, they said, we don't know that about Jim because he's not very fast, he's sort of slow, he's older, but all the customers really like him. His customers like him. During the entire time that I waited tables, I never got a bad evaluation or write-up by management. I never had a letter or statement put into my personnel file. Never. And my relationship with my customers was good. And even today, I will run into somebody from time to time who saw me at the restaurant, or I waited on them and will say something pleasant or nice. Doesn't mean everything was perfect, but on balance, it was good. It reminds me a little bit of what the relationship is with lawyers and clients. If you don't have a good relationship with your clients, it doesn't really make a great deal how smart you are, how much you know, how talented a lawyer you are, if you don't have anybody who wants you to help them. And so it seems to me one of the most important things we can study is, how do you become a better lawyer? How can you go from being good to great? I think there are over 20 to 25,000 people who have licenses to practice law under the North Carolina bar, maybe more now. And that includes out of state. And I suspect that the vast majority of these lawyers are good lawyers. You've got to be good to pass the bar exam, to at least have some basic smarts about you. But what is the number of lawyers? What is the number of lawyers who you might consider great? Of course, it depends on the standard by which you judge that. I would judge the great lawyers are those who improve a client situation from where it was when it started out to where it ends up. And have you improved it any? That's certainly how you're going to judge a doctor. That's how you're going to judge a dentist. That's how you're going to judge a CPA, an accountant. Might you not want to judge lawyers the same way? Mightn't you want to take a look after you've seen this program, and go through the list of your current clients and see how you are doing. Give yourself a test. Make it a private test and grade it sharply, sternly, and see how you are doing, whether there is room for improvement. Have you got an end game plan for your clients? Or do you have any idea what on earth you're doing? Are you doing it intentionally, or are you representing them sort of by accident as things come along? Are you reacting, or whether you're proactive? You know, you've heard me say before that lawyers need to give clients hope. And I think that's true. I think when clients come to see you first, they're frightened, they're nervous, they're anxious, they're scared, they don't know how much it's going to cost, they don't know what the chances of a good result are going to be, and so they don't really enjoy becoming a client. It's not what they have sought out to become. You know, when I was a very young boy, living in the town of Wake Forest, before the college moved to Winston-Salem, I remember being in the backyard with a lady who was pretended to be my grandmother. And she asked me what I was going to be when I grew up. And I said, I don't know. I've never really thought about it. She says, I think you should be a lawyer because you like to argue and you like to talk all the time. You ought to think about going to law school and being a lawyer. That was the first time I'd ever thought about it. I was under 10 years old. So I thought about it all through high school, got on the debate team in high school, took political science and history in college, got involved in student government, graduated from Wake Forest, and went to Chapel Hill to law school. That's what my course was always on. I bet you that many lawyers have very similar courses. You go on to become a lawyer because you've planned it. Many paralegals wanted to become involved in the legal profession, whether it was as a paralegal or perhaps they wanted to go to law school and decided not to, but they enjoyed being in the legal profession. It's something they look forward to doing. They planned on doing it. They took courses. Some paralegals today, as you know, go to these paralegal schools. Well, if you go to a paralegal school, you have to take courses. You have to do well in them. You have to take a test. You have to do well in that. To become a lawyer, you have to go through 3 years of law school. You've got to study hard for the bar examination, which is given, and you have to pass it. And then you have to have a moral integrity sort of thing that people have to vouch for your good character. You have to have people write letters, fill out a very lengthy explanation. This is before you have even gotten a job, for goodness sakes. So becoming a lawyer is something that may happen accidentally, you think, because you just decided to do it on a whim at the end of college. But it takes planning to become a lawyer. It takes hard work to become a lawyer. It takes hard work to become a paralegal. It does not take much work to become a client. That's not totally true with respect to clients who are getting business deals or corporations or companies or real estate matters. Perhaps that takes some planning. But the person or business who is a defendant in a civil suit or a criminal case, or the plaintiff in many kinds of civil actions, does not seek to become a client. I will bet you even those corporate clients, businesses, the business does not set out to become a legal client. It sometimes is a necessity, but that's not what they seek to do. Nobody gets up in the morning and says to themselves, I think today's the day I will become a client. It's not on anybody's bucket list. It's not. And there is the rub. It's very important to understand that. Not only does a person not want to become a client, he or she has to pay money to do that. A lot of money that they oftentimes don't have and have to borrow from family or friends or a bank. And then they come into your office, they sit in your lobby, they're nervous, they're anxious. Perhaps you're not quite on time, they have to wait and they have to have patience. And then you meet with them. Usually across a desk or a table, and talk with them and hear what they have to say. Then they want you to give them some evaluation of how they stand. If I have been given a citation for a traffic case, I want to know what might happen to my case and when might it be heard and how much is this going to cost me. If I'm a defendant in the domestic relations case, I want to know how much is this going to cost me, what is going to happen to my interest in the family matters and economy and the house and my income and so forth. If I'm the plaintiff, the same questions on the other end. If I am a defendant in a bankruptcy matter, I want to know what's this going to be like. What are my rights? What's it going to do to my credit? If it's am I a doctor or a lawyer in a malpractice case, what is this going to do to my reputation and to my career? If I'm a person in a major criminal felony case, what are my chances of avoiding jail, a fine, probation, a penalty? What's going to happen to me? These are issues that come up every day all across the United States. And I can't help but think when the person who becomes the client comes into your office, he or she wants to know as quickly as possible what's going to happen to me. How can I get through this? Do you have any idea of what's going to happen? And how much is this going to cost me? How good are you at what you do? Do I have a chance? When is this going to occur? All those kinds of questions are thrown at you almost at once. Underlying all of this, though, underlying all of these questions, it seems to me, is the desire for hope. The desire to have the situation improve. That there's some light at the end of the tunnel. And that light's not a freight train coming down the tracks getting to run me over. They want light at the end of a tunnel. And they want you to be able to give them some light. I think that's what clients want most. I've talked to a number of people who become clients, some lawyers, some paralegals, some not. I've become a client. I don't know many people who have ever really enjoyed it a great deal. I remember one lawyer in the western part of the state was at one of my programs one time, and she became a defendant in a civil matter, not a criminal, a civil matter. And she hated it because she thought that everybody in the bar, it wasn't a big bar, was looking at her, was talking about her, as if she were in a fishbowl. We tend to think that the whole world is talking about us and looking at us. When we go into the courtroom, we look around to see if there's anyone we know. We want to see if there's anyone in the lawyer's office that we know. We're embarrassed about it, perhaps. So we want to feel good about ourselves. our self-esteem oftentimes has taken a hit. We're not as confident as we were. The day before we became a client, we were not a client. And what that means is we had some management or control over our life, over our time, what we did, who we spoke with, how we interacted with other people. But when I became a client, as I did back in the early 1990s, that all changed. My lawyers, Rick Gammon and Wade Smith, now had an interest in how I was doing. They could call me and check in. They could ask me to come to their office and meet with them. They could ask me questions that I needed to answer. Wade Smith recommended I see a doctor, a psychiatrist in Durham, and eventually I did so. None of this would ever have happened. None of it had I not become a client. And so that was a very revealing time for me. And I wish that somehow I could say to you how important I think it is for you to have a really good relationship with your client, and that you are able to improve, even marginally, the situation of the client at the end as well as at the beginning. And that is a very broad field. That's a very broad field. That does not mean always that I, as the client, am going to win, or to be found not guilty, or to have to pay no money, or to have the charges or the complaint dismissed, and that I get attorney's fees, or this sort of thing. Or it doesn't mean that I'm going to collect a great deal of money. You got to remember that if I'm collecting a great deal of money on a civil action, something has happened, something has gone wrong that allows me to be compensated monetarily by the legal system, to compensate me for something that has happened. That's a win on one hand, but I had a loss on the other that perhaps caused me to have to hire a lawyer, to bring an action, to be a plaintiff, to get some monetary result. So the question then becomes, have I really improved my situation from where it was at the beginning and the end? Perhaps financially I have. If I've been found not guilty, of course I've improved. If I have gotten to save my house in a foreclosure matter, or I'm out of bankruptcy, perhaps that's good, can restore my credit. That's improved. What makes a situation better at the end than it was at the beginning, if that's my definition of what is a great lawyer, which for the purpose of this program, it is. It depends on what kind of lawyer you want to be. I have run into opposition from some attorneys who have said to me that they do not believe that their job is to look after the mental well-being of their client or their social well-being. Rather, it's their job and their job alone to look after the legal well-being of the client. I understand that, and there is certainly every room for that in many kinds of practices of law. If you are a lawyer, let's say in a city or town in North Carolina or some other state, South Carolina, and you are what we would call a district court lawyer in matters that don't get to the superior court level, and you represent people in traffic court, then what they are looking for in that particular matter is, of course, a legal result, a compromise perhaps. a limited driving privilege or a lesser plea that has no insurance points. If you're in domestic court, maybe you're looking to have custody or a certain amount of alimony or child support or a split of the equitable distribution, or who's going to have visitation rights with the house, this sort of thing. And maybe there you just look at the legalities of the situation. I'm reminded, though, a lawyer friend of mine in Newbern, North Carolina, who once came to my program, who does a lot of domestic work and does it very well, very successfully, said to me one time, he said, you know, Jim, I tell many of my clients, I can get for you the visitation you want on holidays and that sort of thing, because there's sort of a formula in this county that we use. The greater question that I would like to assist you on, though, is to represent you in such a way, and you act in such a way, that when your minor child becomes a legal adult or a sufficient age to make a decision on his or her own as to whether they would like to spend time with which parent, they will want to still come see you, even though they are not required to do so by a court of law. That would be improving your situation from oftentimes where it is when you're starting out to where it is at the end. If you looked at my situation, in January of 1993, when I first went to see Wade Smith and Rick Cameron, I was clearly in jeopardy. I was in jeopardy with respect to the state bar, and I was in jeopardy with respect to the district attorney's office in a legal matter. I had not yet been charged. I had not yet turned in my license to practice law. So when I first met with Wade and Rick, nothing bad had happened yet except my own conduct. It was all out there in the future. And so the question became, how did I get from point A to point B, if B is at the end, in one piece? I suppose what I wanted most from my case is I wanted to know what was going to happen to me, and I wanted to mercifully be over as soon as possible. And I wanted the least bad things to happen to me. Does that sound familiar? It should. It's what most clients who are in trouble want. It took, however, some time. I think sometimes the race is not to the swift, but the race goes to the person who stays the course. And sometimes staying the course and letting time work its magic is just very important. In my case, time worked through the shock to myself, to my friends and former colleagues as to what I had done, shock of turning in my law license, the shock of being indicted by a grand jury in Wake County, the shock of going to see a psychiatrist for many, many sessions, the shock of reading about myself in the newspaper, of pleading not guilty and changing that not guilty plea to a guilty plea and entering it in court and answering questions under oath, and then being sentenced to court, to jail. And then a month or two after that, actually going to jail in prison for 3.5 months. And coming out, having no job, no prospects of a job, and having to start all over and having to pay a lot of money back to the law firm. How on earth was I going to do this? It was as black a hole as I possibly could have dug for myself without shooting myself. But as Wade is fond of saying, if no one has died, I guess everything can be fixed. That sounds sort of trite. It's not. Fixing is a broad term. It doesn't mean putting Humpty Dumpty back together again. It means making you different from who you were before and figuring out a way to do that. If my lawyers, think about this, if my lawyers had represented me strictly on the legal case, what they might have done is had me plead guilty immediately after the indictment. Not worried too much about seeing a psychiatrist. Gone ahead and turned my license into the bar. Been indicted, pleaded guilty, and gone to prison. And that was it. They could go on to their next case, thinking they had done all they can do because Jim had made such a mess of things. There wasn't anything anybody could do for him. He had left a paper trail a mile long. He was guilty as the devil. What are you going to do for somebody like that? There's nothing you can do except end it. That would have been, they could have done that and the bar could have done nothing to them. They would have represented me well. They would have represented me under the law. They could have returned my phone calls and talked to me and answered all my questions, so they'd been that kind of communication, but they would have done nothing more. And what would have become of me? Maybe they could have gotten me a plea bargain agreement, a few counts dismissed, plead guilty of the others, that kind of thing. It's a cinch if they had done that. It's a cinch if they had done this. I would not be here taping this interview or this presentation to you for the bar. Credit. It's a cinch. Some lawyers do not think they ought to try to help me out from a psychological or mental point of view. And certainly that's true. A lawyer is not a psychiatrist. A lawyer is not a psychologist in most cases. That's not what a person goes to law school to do. A person goes to law school to become a lawyer and to learn the law. But a lawyer also is supposed to be a counselor. I know that if you look at the license, it says attorney and counselor at law. What does that mean? It can mean whatever you want it to mean, but I choose to interpret it in its most broad sense. And that is to say, one of the best decisions that was ever made for me by a lawyer was the decision to call Dr. Spaulding the first 24 hours I met with Wade Smith and to suggest and then push me to go see her. Now, it started out, they were trying to figure out what on earth happened to Jim to cause him to go off this way. Is there something we can use as a defense in this case? Or does he have issues that transcend this case and that he needs to be concerned about his life ever after? There's nothing in the law that says that they had to suggest that I go see a psychiatrist. Nothing. But they did. Of all the decisions that were made on my behalf, that's probably one of the best ones, and yet that's not a legal decision. It is the decision, however, when you don't know all the answers to a situation. Get another opinion. That other opinion does not have to necessarily be a legal opinion. It could be a psychological opinion, as it was, in my case. If someone else knows more than you do about something, you wouldn't hesitate to ask a person about tax law or domestic law or if there are other aspects of law entered into your case. so should you consider with respect to the psychological aspects as well. At least I think so. You know, I think back so much to that early time, and I remember I wasn't happy with the suggestion to go see Dr. Spaulding. And in fact, I resisted it because I said to it I really didn't believe in psychology or psychiatry or anything. And he pushed me on that, and it took about 48 hours for the push to come hard. But I did eventually go see her, and I kept going to see her for a number of years. I think that clients who come to see you, they're in your hands. They are turning themselves over to you. It really is an honor to you that they have asked you to represent them. And lawyers and paralegals who forget that do so at your peril. Because, of course, if you don't have any clients, you don't have any law practice if you're in private law practice. So you have to have clients. And you have to give them hope. I think you have to. If you can't give them hope, what good are you? Why would I want to come see you if all you can tell me is I'm going down? Why do I need you to tell me that? If I'm going down, can't you make the path down a little bit easier for me? Can't you make it a little bit nicer a walk than just being thrown into a well? I can do that by myself. And so it was that I needed to get some hope from my lawyers. Now, I knew Wade and I knew Rick, and I had a level of trust and confidence in them because I had known them for years. I had met Wade first in 1979 when he was a defense lawyer for Jeffrey McDonald, and I was the prosecutor. I met Rick Gammon when he was a rising third-year law student at Campbell University Law School, and he interned in the United States Attorney's Office when I was United States Attorney. That's where I met them. So I had known them for a long time. I had known Rick and Wade at that point for well over 20 years each. I had known Dr. Spaulding not at all. I met her and spoke to her for the first time when I went to see her for the first time, for my first appointment. And I had no idea what the future with her held. I had no idea how long I would be seeing her. I did not know how much money she was going to charge me, how I would pay her, whether she needed a retainer, how any of that would work. I didn't know anything, much like many clients go to see lawyers. And so it was that the issue of trust became paramount. In order for me to help the lawyer, in order for me to help the paralegal, I have to somehow begin to tell them the truth about my case. And I need for them to be patient. I need for them to listen. I need for them to have some empathy, if not sympathy. I need for them to look as though and say that they understand where I'm coming from and what I'm talking about. I need for them to know that I am frightened and insecure and want to hold on to them. I need for them to not be judgmental. I need for them to be steady and calm. I don't want to come to a lawyer who throws his hands up and says, "Oh my God." That actually happened with me a couple of times in my relationship with my lawyers, the "oh my God" response. when they heard some of the things that I'd done. I remember it well. By that time I was steady enough to get through it, but I remember some of the oh my gods. That's a tough thing to say to a client, you know? But let me tell you something. How you build trust with a client is that you listen and you pay attention and you probe gently and you ask to meet for them the second and third and fourth time. You don't throw thunderbolts at them right at first. You don't tell them they're going to get the death penalty the first time you meet with them. You tell them that there's more to learn. We will get through this. You're on their side. You want to help them. That whatever they say to you will be held in the strictest confidence. And you will do your best. You will be with them until the end. They want all that, and they need all that, and they deserve all that, and they expect all that. And that's the first stage on getting somebody's situation better than it was at the beginning. But how in the world can you do that? You can't do that, frankly, if you don't know where they are now. If you don't know the true facts of the situation, it is impossible to improve it, really, from where it was. It may be worse than what they have said when they first come to see you. Likely, it is. Likely, it is worse. On whichever side somebody comes to see you, because it's likely that the client has a hard time telling you everything. You know, the truth of the matter is, I think I had seen Dr. Spaulding. I think it was the third visit I saw her. And she knew much of my story then. But she did not want me to tell my kids everything quite yet. She sort of wanted to dribble it out a little bit. And I told my lawyers, Rick and Wade, pretty much everything. I don't think I told them everything the first time I met with them. I am certain I did not. I am certain I did not. Not because I was trying to keep things from them, that I probably was, but because I hadn't yet got my arms around it myself. And I couldn't yet quite bring myself to what had happened myself. Once I said words to them about what I had done, it became all too real to me. And so that was hard for me to do. And so I want to say to you, be patient with clients. Give them some running room. Give them some space. But before you can know whether or not you can improve the situation, you first have got to know where you are. And you won't know where you are on the first meeting, in most cases. You may not even know where you are on the first meeting on a traffic case. They will only tell the story in its way that's most favorable to them. The first question that Wade asked me when he sat down with me at the restaurant at Tripp's in Raleigh that cold Wednesday afternoon was interesting. He said to me, I want you to tell me the worst thing you have done. Not the best thing, but the worst thing. And I remember shrugging my shoulders and said, well, this may take some time. And he responded, that's okay. That's one thing we have. We have plenty of time. We do not have to do it all today. And we didn't. We did not. And I started talking with him. And I don't know how long we talked, maybe an hour, hour and a half, probably not much longer than that. he took a lot of notes, and I had told him enough, though, in the first meeting that he knew my legal career was shot all the kingdom come. He knew that. And he knew I needed to talk to Dr. Spalding. He knew that too. But I hadn't told him everything, not because I was trying to keep it from him. It just was hard for me to do so. And so might it be with some of your clients. It's hard for somebody to admit the worst things they've done. If you don't think so, you should try it yourself and see. How would you be as a client? What would you want from your lawyer? Would you want judgmental, or would you want non-judgmental? Would you want patience or no patience? Would you want understanding or no understanding? Would you want some time and space or no time and space? Would you want the brutal truth from your lawyer the very first meeting? Or would you want it down the road? I got it down the road, and it wasn't very long after the first meeting. Don't misunderstand me. They didn't hold back. I wish they had held back sometimes, but they did not hold back. They came at me pretty straightforward. They never promised me a rose garden. And I sure as heck did not get one. In order to improve the situation from where it is to somewhere else, though, you've got to not only know all the facts of your case and what surrounds those facts, so has the client got to know that. And so I think does the client have to know the parameters of what could happen, what potentially might happen to him or her. Or else they're not going to know whether or not the situation has improved or not. And so I think it's very important for everybody to get on the same page. And getting on the same page in those first 2 or 3 meetings is so important. If I were practicing law today and I got a phone call from a client who wanted to come see me, I'd want to know why, what it was about, and then I want to think about it. I really would like to spend some time just thinking about why the client is coming to see me. What is it about? Is this in an area that I can handle? Is this an area of my expertise? Now let me talk for just a couple of minutes about something really straight here. One of the ways to get in trouble with your clients or with the bar the quickest is to represent somebody in a matter you don't have a clue what you're doing. And you think that you're going to learn what you're doing on the dime of the client. That's a mistake. I think that's one of the dumbest things you can do. Have this rule. Would you be willing to tell your law partners, or if it's you in private practice by yourself, your secretary or paralegal or somebody, that you have taken this case and they say to you, good, that's something you should be doing, that sounds interesting. I think you can help this person. What are you going to charge them? What are the terms of your relationship? And you say, well, I don't know. They don't have much money. I got to maybe give them a break. Maybe do it on the side. And you think you're doing them a favor. You may not be doing them a favor, because if you don't have some structured agreement or understanding with the client, you've set up the possibility of a misunderstanding later. One of my great friends in the practice of law once told me, and this is so true, that an understanding now avoids a misunderstanding later. An understanding now avoids a misunderstanding later. And so it seems to me that a structured understanding of what the terms of the representation are is important. What are you going to do for the client? What are your expectations from the client? What are the terms of the financial arrangement with the client? How is that going to be met? Can it be done? Is this something within your expertise? Have you looked to see if there is any conflict of interest? Have you ever represented someone else in your past that somehow has some relationship one way or another, either directly or indirectly, with this case that you're now considering taking? If it is this a conflict that is major, or is it way in the past? Would the conflict or potential conflict have an impact on your ability or willingness to represent the client in a professional manner? Would it? When I was in a large law firm, we did conflicts checks, and I always got exasperated when I perhaps could not take a case or a client that I wanted to take because of some conflict on the part of some other lawyer whom I hardly even knew represented somebody down the road. But yet, while that is frustrating and perhaps disappointing, it is a safeguard. It is a safeguard that will keep you out of trouble and out of harm's way. And it is one of the ways that you can ensure that your representation of this client is the zealous representation of a client. That's what you want to do, isn't it? I think it is. And so ask yourself these questions when the client first comes to see, what is it that I want to accomplish with this client? Do I have any idea of a plan? Perhaps not at the first meeting, but have I thought it through in any general way? And do I decide what is a fair fee? Do I know enough initially to charge a fee from both me and the client, or do I need to come back after I've done some research and looked into the matter? Is this something that I can be proud to tell other people I am doing, or am I doing this out of the back seat of my car and hopefully nobody knows? Have I taken on a case that I really did not want to take, but am doing so against my better instincts and judgments because I, A, perhaps feel sorry for the client, or B, the client has gone, several other people haven't got anybody and they're sort of begging you to take the case and finally you agree to do so, or it's the son or daughter of a friend, or it's a friend, his or herself, to you. Be careful. The bar will not get on you for not taking a client. You can't be sued for not taking a client. You cannot lose your law license or be suspended for not taking a client. What you can get into trouble with is taking a client and not doing it well. And what I am trying to say in this initial time period, this is perhaps one of the most critical time periods of the whole relationship that you have with a client, is know what you're getting into. Do it with your eyes wide open. Don't put on any blinders. And be totally straightforward and truthful and upfront with your client. Put it in writing. It's too bad we have to put all these things in writing because that implies, I guess, a lack of trust, but we have to do that to protect ourselves, and you have to do that to protect yourself. And it also protects the client as well. Don't give unreasonable expectations to the client in the hopes that that's going to cause the client to retain you as opposed to somebody else down the street. If they're attorney shopping, just be straightforward and tell them that you will do your best, what their situation generally is about, but do not promise them a result. Don't guarantee them a result. Don't say the words to them, I can do this better than anybody else. Maybe you can, but maybe you can't. I know the great cliche, it's better to under-promise and over-deliver. It's better to under-promise and over-deliver. Well, of course that's true. Makes common sense, doesn't it? What is not good, however, is to over-promise and under-deliver. And I do know that much. Do not overpromise and then you come back and underdeliver. That's where most people get in trouble. Good Lord. Let me tell you, that's probably where I got in trouble as much as anything, by giving people unreasonable expectations that I could not possibly live up to. And then I spent all the time trying to figure out how I want to live up to those. I didn't get into trouble because I didn't want to live up to those expectations. I wanted to very much. I just couldn't do it because it was not possible, either because of the law or because of the factual situation. I could not make horses fly. I could not make horses fly, and neither can you. I was as close as anybody ever needed to being able to do that, but I could not do that. And it was that inability to do that that caused me to get in trouble after implying to the client that perhaps I could get horses, to fly. That's such a bad thing. I know it's one of the principles of bars of almost any state in the United States that clients want the zealous representation by their lawyer. What in the world is the zealous representation of a client? Is it something you can see it? Is it like Potter Stewart once said about the Justice of the United States Supreme Court, like pornography? I can't define it, I only know it when I see it. Is it that nebulous? What is the zealous representation of a client? It is certainly doing your very best. And it is doing with a great deal of passion. And it is doing unconditionally for your client. It is working as hard as you know. It is leaving no rock unturned. It is communicating regularly, openly, and honestly with your client. It is listening to your client. It is being patient with your client. It is telling your client the truth, giving them the best options. And then when they ask you what you think, giving them your best educated guess. It is being with them and not leaving them in the lurch. It is being well prepared. It is thinking of all the things you can do. It is bringing all to bear on this one case, all your training as a lawyer, or all your training as a paralegal. Paralegals are so unique in our legal system. They can help a lawyer look really good or not. And paralegals oftentimes get closer to clients than the lawyer, because the lawyer talks in gobbledygook and the client can't understand what on earth the lawyer is saying, and so they turn to the paralegal and say, will you please explain to me what he or she, the lawyer, just said? What do they really expect from me? What is really going to happen? I can't get the lawyer to tell me what's going to take place. What's likely to happen to my case? What are the results that are likely to take place? What do you think I should do? Do I have any chance? What are my options? What are my chances? They oftentimes will talk to paralegals about this, not the lawyers. Because the lawyers talk in fancy terms. Or they are busy. They're in court. They're meeting with other clients. It's easier for me to let my paralegal talk to the client because it's a lower hourly rate. And it's cheaper. And it's a way to also make more money because you allows you to be two places at one time, a lawyer somewhere else and a paralegal with the client, but at a cheaper rate. And that's all good. That's all well and good to do that. There's nothing wrong with that whatsoever. But just remember, every time you delegate as the lawyer, the client to deal with a paralegal rather than yourself. Every time this happens like that, that is one time they have not spoken with you. That's one time they have not communicated with you. But if the client can talk with the paralegal, knowing that when they do so, they are in effect talking with you, because the paralegal is going to relay that message to you. Or when the paralegal is giving some suggestions or jobs or responsibilities to the client knows that's coming from you, that's just an extension of you. If you can develop that kind of relationship with the client, then that's all to the good. Then that's the way to use a paralegal, as your extension, not as a substitute, because you're busy, and but as an extension of you. If you say to them, I won't be able to talk with you every day, but my paralegal can and will, because I'm going to ask them to do so, and I want you to know when you talk with the paralegal, you are talking to me. So you feel free to talk with them and ask them any question you have. And if I've not explained something to you well, ask them and they will ask me, and I will try to get back to you and talk to you myself so that you understand. Talk to me that way. And I want you to feel free to talk to me. And that's the way to professionally handle a relationship with the paralegal and the client and the lawyer. But to do so zealously, to do so with passion, with great interest, to recognize that it is a tremendous honor to be asked by any client, to be represented by you. Because he or she, the client, or the business or entity or whatever, is turning over to you and your legal capabilities, their future, as well as their present. The questions that I wanted to ask you in this particular matter: what do clients want most from you? The answer is hope. And the other question is, how do you go from being good to great as a lawyer? My judgment is to improve the situation of the client at the end than what it was at the beginning. Those are the two questions for this hour.